Does the First Amendment protect the statement, "Charlie Kirk deserved to die, and I hope he burns in hell"? Hi, my name is Paul Matuka. I'm an attorney with the Oliver Bell Group, and I primarily litigate civil rights cases. And today, we're going to talk about the First Amendment and what it does and does not protect. So the statement I just made is actually protected under the First Amendment. That means that I cannot be arrested or harassed by the government based on that statement. And the courts have consistently upheld the First Amendment and its broad protections. For example, Nazis have First Amendment rights to be Nazis, and that's just how it is. However, the First Amendment doesn't protect all speech. Certain things such as true threats, incitement to violence, and slander and libel are not protected under the First Amendment. How do you know if your First Amendment rights have been violated? Well, the first question is, did the government do something to you, or was it a private employer? If you're an employee of a private company, then the company can retaliate against you, fire you based on your speech if they disagree with it, because they are not bound by the First Amendment. On the other hand, if you're employed by a state or the federal government and you're retaliated against based on your speech, you may have a First Amendment case, but it's not simple. There's a number of steps or a number of factors that need to be considered before determining whether you have a case. The first one is whether you made the statement or statements in the course of your official duties or as a private citizen. Did you post it on your personal Facebook account, or are you a cop giving a press conference making a statement? If it's made in the course of your official duties, you're not protected, and you can be fired for your speech without any First Amendment issues. If you make it as a private person, then you go to the next step, which is whether you were speaking on a matter of public concern. This is fairly easy to determine. Essentially, if it's in the news, if it's newsworthy and it's big, it's a matter of public concern. So Charlie Kirk's death, I would say that's a matter of public concern. This means that you have a protected First Amendment right in the speech, but that's not where it ends. The courts next go to what's called the Pickering balancing test, which balances the interests of the public employer against the employee's First Amendment rights. And here the courts are hesitant to control the hiring and firing within public agencies, but they also recognize that First Amendment rights need to be protected. And here, the courts will determine effectively whether your statements affected the ability of your employers to continue functioning efficiently or undermined your ability to perform the job. And I've got a couple of examples here to go through. The first one is Rankin versus McPherson. This is a case that arose out of Texas, and it involved a secretary working at a police department. And after an attempted assassination of then President Reagan, she said something to the effect of, "I hope they don't miss next time." And she was fired for that. But that statement was made within the police department and not published to other people. The Supreme Court found that that firing was unlawful and violated the First Amendment because it did not affect her ability to do the job, and it did not undermine public confidence because she was a secretary and the statement didn't get broadcast outside of the department. On the other hand, if we look at a case such as City of San Diego versus Roe, which also involves a police department, there a police officer was making adult films on his personal time and, selling those on eBay. But he did this in a police uniform, not the official one, and it was noted that he was a police officer on his account. He was fired after this was identified, and that firing was upheld because of how that could be perceived by the public and how his conduct could affect the department's mission. Another example from a police department comes from the First Circuit, and this is Hussey versus City of Cambridge. In this case, a police officer made derogatory comments on a Facebook post about George Floyd. He called him a druggie and a violent criminal. He later removed this post and his Facebook account was set to private. However, the NAACP found it and made a complaint to his police department. He was then disciplined and sued. Here, the First Circuit found that discipline was appropriate. And while he spoke as a private citizen on a matter of public concern, the department's interest in efficiency and its mission justified the discipline that was imposed. The final example involves a school teacher, and this also comes from the First Circuit. This is McRae versus Matos, and this involves a teacher who was making TikTok posts that denigrated trans people and were racist in some cases. And the school fired her, and the First Circuit found that that firing was appropriate, and the Supreme Court denied certiorari. These cases demonstrate how complicated First Amendment litigation can be. And here at the Oliver Bell Group, we stand for civil rights, we litigate civil rights, and we believe in the First Amendment. And if you think that your First Amendment rights have been violated, contact us immediately.